I'm Michael Jacobson. I'm the director of Vera. I want to just speak for a minute and first just welcome everyone here for what I think will be an interesting exchange of ideas about secure communities. I certainly want to thank our co-sponsor, New York Law School, and certainly to our distinguished and busy panel who made time to come here and do this. So one of Vera's main areas of work is on immigration-related issues. That work takes sort of two different forms. One is we get legal information and counsel to people who are in detention. For the most part, they're in detention and facing deportation. That's a big part of what we do. We do that work all over the country. And the second form our immigration work takes is on work between the intersection of immigrant and new immigrant communities and law enforcement and police departments specifically. And so, clearly for us, those areas of work are certainly impacted directly and indirectly by secure communities. We have other big areas of work we do around adult sentencing and corrections, juvenile justice, victimization and safety, race and prosecution, substance use and mental health, cost-benefit analysis. All the work we do at Vera is, in one way or another, directly or indirectly, impacted by secure communities. And so for all those reasons, it made sense for us to host a discussion where I think several points of view will be heard, and it's obviously there's a lot of interest in this generally, and for us, the question of how secure communities works, whether and how it's a effective law enforcement strategy is not just an academic question, but it's really meaningful to a lot of the stuff that we do, and obviously to the issues that you work on and are interested in. And so I want to just take a second to thank all of you for coming as well. Our moderator tonight is Susan Shah. Susan heads probably 3 different Vera programs dealing with relations between immigrant communities and law enforcement. Susan is a longtime Vera person, and she'll be moderating and guiding tonight's discussion. So I'll turn the podium over to Susan now.
So good evening. Secure Communities is a federal program that was launched in 2008 and has been activated in approximately half of the jurisdictions nationwide, according to the Immigration and Customs Enforcement of the Department of Homeland Security. DHS plans nationwide activation of Secure Communities by 2013. Since its introduction, the Secure Communities program has met with resistance by advocates and officials in several state and local jurisdictions who argue that it raises serious due process concerns and casts too wide of a net. Concerns have been raised about the program's effect on immigrant communities, including racial profiling and fear of law enforcement, as well as costs to states and localities. The states of Massachusetts, Illinois, and New York have declined or suspended participation in Secure Communities, along with over a dozen local jurisdictions with large immigrant populations. Among these, Cook County, Illinois, and most recently Santa Clara County, California, have gone beyond and enacted legislation to prevent information sharing with immigration authorities. This evening we'll be discussing Secure Communities, and we have a very well-informed group of panelists who have specialized knowledge of how Secure Communities, or Escom, will impact law enforcement and immigrant access to the justice system. In alphabetical order, we have Gary Mead. He's the Executive Associate Director for Enforcement and Removal Operations for the U.S. Immigration and Customs Enforcement of the Department of Homeland Security. He oversees a $2.5 billion budget and more than 8,000 employees. From 1974 to 2006, Mr. Mead served in the U.S. Marshal Service, where he held a number of senior executive service law enforcement and administrative positions at the associate and assistant director levels. Mr. Mead holds a master's degree and received 2 Senior Executive Service Presidential Rank Awards. Next, we have Sunita Patel. She's a staff attorney with the Center for Constitutional Rights. She litigates racial profiling, immigrant justice, and other human rights issues. She is currently involved in litigation related to secure communities and other immigration enforcement activities. Previously, Ms. Patel held a Soares Justice Fellowship with the Legal Aid Society's Immigration Law Unit in New York City. At Legal Aid, she represented immigrant detainees in removal proceedings and worked on detention oversight. She received a JD from American University Washington College of Law. Next, we have Peter Schuck. He is the Simeon E. Baldwin Professor Emeritus of Law at Yale Law School, where he's held the chair since 1984. His major fields of teaching and research are immigration, citizenship, and refugee law, torts, and administrative law. Prior to joining Yale, he was the Principal Deputy Assistant Secretary for Planning and Evaluation in the U.S. Department of Health, Education, and Welfare. Professor Schuck holds a JD from Harvard Law School, an LLM in International Law from NYU, and a Master's in Government from Harvard. And last but not least, we have David Soares. He is serving in his second term as Albany County District Attorney, a post he was initially elected to in 2004. Mr. Soares has been focusing on reducing street violence, community restoration, and reentry issues. Previously, Mr. Soares worked for the Albany County Airport Authority, and he was an assistant district attorney in Albany County, where he was one of the office's first community prosecutors. He graduated from Albany Law School. So the format of this evening is as follows. We will begin with a structured, moderated question and answer session that I will be leading for about 45 minutes. And then we'll be inviting all of you to ask questions to the panel. So our process for doing so is going to be through written questions. So you all have cards that have been distributed to each seat. And we have two Vera staff who will be walking down the side aisles. They're right at the Jessica and Elise. And we ask that you write your question on the card and pass it to the side aisle. And they'll be collecting them throughout the program. If your question is directed to a specific panelist or panelists, please indicate that on top of the card. And just know that we're going to try to get through as many as possible through the course of the evening. If you would like a second card, those two individuals will also have extra cards for you. Okay? Well, I'd like to also just flag for you that you have a handout that was also distributed to each of the seats, and that I think will help guide our first kind of round of questions that we'll be going through. So what I'd like to first do is walk through the steps of secure communities, starting with when an immigrant is arrested and booked by law enforcement. So that individual's fingerprints are taken as part of the booking process at the jail. And then there is electronic sharing that happens of those fingerprints with the State Criminal Justice Agency. In New York, it's the Department of Criminal Justice Services, DCJS, and with FBI. And the purpose for this is to get a record of the person's criminal history. Then, under secure communities, the FBI would automatically send their fingerprints to DHS to check with their immigration databases, which are called Ident, for ICE to determine whether to take an enforcement action. And typically, that is removal. And then, therefore, hold the person for an ICE pickup. I'd like to, ask Gary some of the more kind of fine technical questions related to this. Gary, can you tell me where the information that's contained in the Ident databases comes from?
Sure. Basically, the Ident databases consist of any biometric information accumulated from any part of the immigration process, whether it's visas, naturalization, anyone who has had an encounter with the immigration process before in terms of an illegal entry or deportation. So any of those encounters would have biometric information in the Ident databases.
And then what does ICE consider when there is a match when deciding whether to place a detainer on somebody?
Well, that actually goes back to our basic mission. Our basic mission is to identify and remove from the country anyone who is determined to be here unlawfully. We've got the resources to remove approximately 400,000 people a year, and we could remove the first 400,000 that we encounter, which I don't think any of you would think is a smart way to enforce the immigration laws. or we can have priorities, and we have 4 very clear priorities. They are.
And Gary, we'll get to the priorities. We'd love to discuss that further. So if you don't mind, let's hold for one moment
I think it does answer your question. When we get the match, we apply it against our priorities, which are criminal aliens, ICE fugitives, people who have been ordered removed from the country and did not depart, repeat offenders, people who have left the country or been removed from the country more than once and returned, and recent border crossers. So when we have a secure communities match, the first thing we do is see which of those 4 categories they fall into and whether or not the person would be removable based on where they would fall under those priorities.
Okay, great. Yeah, and we'd love to hear more about this. And then if the person, if the information gathered doesn't yield a match, what happens then? Does DHS store that information, or?
No. If there's no match, we don't do anything with that.
Okay. And then there's been some recent reports about or questions about kind of errors with the data. Can you just talk about how ICE is safeguarding against any errors that come up through the secure communities process with with the Ident database?
I'm not sure what you mean by errors in the database.
If, for example, if citizens are included, or if there's other.
Sure. As I said, our mission is to identify persons who are subject to removal, and in order to do that, we have to look at all the immigration records, and some of those records are for naturalized citizens. And there may be occasions, they're rare, that we have to interview someone who's been arrested to determine if they are in fact a removable alien. In a very small number of cases, they might be a naturalized citizen or someone with derivative citizenship, and as soon as we determine that, we basically cease any interest in them.
Okay. And then, going really quickly to the detainer piece. So if ICE wants to take custody of an immigrant, they issue a detainer. And the ICE director, John Morton, has noted that the detainer is a request for a 48-hour hold. Can you just talk about how DHS has been responding to Cook County and Santa Clara County, who are now declining to honor the detainers?
Yeah, we continue to work with Cook County to convince them that what they're doing, in our opinion, is not a smart thing to do. And we are attempting to work around that as best we can to protect the community from people who are going to be released from Cook County custody that would be removable if we were aware of them, and hopefully we can apprehend some of them. But I think the ultimate solution is for Cook County to resume honoring our detainers.
Okay. And anything specific to Santa Clara? I know that's more recent.
Santa Clara is just starting, so
okay.
we're not, quite in the same place we are with Cook County yet.
Okay. Okay. So let's take a moment and talk about what's happening in New York. So other than secure communities, what are the other ways that ICE is enforcing immigration laws in New York?
Well, as you probably well know, secure communities is really just an enhancement to what's called our criminal alien program. For many, many years, INS and then subsequently ICE identifies criminal aliens by having our officers work with county jails to review biographic booking records to see which of those persons in county jails or state prisons are foreign born. We then check our immigration indices, we interview the people, and we take whatever actions appropriate. The overwhelming majority of the people that we remove from the United States every year are not removed via secure communities. They are, in terms of criminal aliens, they are removed through the criminal alien program. And as I said, that has gone on for many years and continues to this day. We have probably close to 100% coverage of all the jails and state prisons in New York, and that's the predominant way we do our work. About half the counties in New York are covered by secure community. New York City is not.
Okay. And so, just for those of you who aren't as familiar with this, so, in any of the precincts in New York City, when a person is fingerprinted upon arrest, are those fingerprints then shared with ICE?
They are not.
Okay. Okay. So, I'd like to just take a moment and now hear from Sunita. Can you talk about what the advocate's perspective has been on the role of Escom and, maybe localize it to New York a little bit as well?
Sure. So some of you here are probably very familiar with what's happened in New York with secure communities. There's a very active advocate network. I see some familiar faces here from different organizations in the New York Coalition. And through a series of advocacy attempts, the governor decided, in consultation with law enforcement and other allies, to request that they be their contract for secure communities be terminated. It's been the view of advocates in New York, and especially in New York City, that the role of immigration enforcement and law enforcement should not be merged. We're in a state now where the Immigration's Customs Enforcement Agency has learned from its embarrassments through home raids and raids of many of the plants, like the Swift meatpacking plants, and has made a concerted effort and said, well, what can we do so that we can prevent the public nightmare and the public embarrassment? And they've said one of the ways we can do this is to push enforcement behind jail walls. So it's true, the criminal alien program is something that people don't know very much about at all. It's as you've heard, it's in 100% coverage in New York, and not very many people know about it. And now we have secure communities, which was also a program that was being rolled out with very little transparency or information in the public's eye. It wasn't until there was my organization, along with some other groups, decided to file a lawsuit under the Freedom of Information Act to obtain data and statistics and other information, that any information, meaningful information, became known and became public. So from the advocate's perspective, I think it's not just about secure communities, it's about the merger of these two systems. The role of law enforcement is very different than the role of immigration enforcement. It makes communities less safe to merge these two systems. Victims don't want to come forward. Even police have said that it makes their jobs harder. And quite frankly, ICE is just pushing the liability, the cost, and the criticisms to the states and local police. And they shouldn't be allowed to do that.
So, so is any of your work right now with the FOIA request, we're not focusing on New York? Are you guys focusing on New York at all, or has it been more in other jurisdictions or national, just to kind of,
Sure. So just to explain a little bit, the National Day Labor Organizing Network, the Center for Constitutional Rights, and the Cardozo Immigrant Justice Clinic filed a series of Freedom of Information Act requests to several federal agencies, including the Department of Homeland Security, ICE, and the FBI. And through that request, we've received thousands of emails, internal emails and documents related to secure communities. We've also received a lot of data, and some of that data does relate to New York City.
It does relate to New York, okay. So let's talk about this kind of in a broad sense now, that we've kind of fleshed out the process a little bit. So Gary, you had started to talk about the stated priorities of ICE. Can you talk about how this is being implemented, and can you share data related to who's being deported under the priorities?
Yeah, a couple of things as part of that. Secure communities is very well described in this document that you have in front of you in terms of what it actually is. It does not divert any local law enforcement resources. Local law enforcement is not authorized to take any action on behalf of immigration. Local law enforcement is encouraged to do what they always do, which is arrest people for probable cause if they feel the facts warrant it, and to submit the prints if they think that's appropriate. And when the match occurs, ICE officers, not local police officers, determine what, if any, action to take. They don't expend any funds on secure communities. If we do file a detainer, yes, they could be asked to hold that person for up to 2 days at their expense, but local law enforcement has the ability through the SCAP program, the Department of Justice, to request funding to cover those costs. So there's a lot of things about it that, that have been said that aren't quite accurate. As far as New York State goes, as far as I know, the New York State Sheriff's Association has endorsed secure communities. The New York State Association of Chiefs of Police have endorsed secure communities. I can tell you that in Illinois and in Massachusetts, there are many, as in New York State, there are many law enforcement agencies lined up asking us to activate secure communities prior to the end of 2011. So I think it's a mixed bag. There are 43 states currently with some level of activation. Only 3 have voiced any concerns about the program. There are 1,500, actually almost 1,600 jurisdictions active. Less than 10 have voiced any concerns about the program. So I think it's important to put in perspective the criticism, which is obviously real, but it is not universal. It doesn't even approach the majority of the places where the program exists. And I do think that the program is basically smart law enforcement, is consistent with our priorities, and it does make communities safer. There's no, as far as I know, we've not been made aware of any jurisdiction where they actually have evidence that it's deterred witnesses from coming forward to report crimes. We hear these anecdotal stories about that happening. We've heard that victims of domestic violence are being scooped up and deported as a result of secure communities. We have not been able to document a single case where a victim of domestic violence identified through secure communities has been removed from the country. And so, we recognize that the program can be improved. We're looking at how we deal with low-level traffic offenders, for example, who have no other aggravating conditions either in their immigration or criminal history, to see if we could be doing something different with them. We are doing everything possible to improve the communication and the accuracy of the communication. I'd invite you to go to ice.gov and click on Secure Communities. There's a lot of good information there that is recent, at least since the early part of the summer, describing the program.
Well, Gary, let me ask you, if this is, I'm going off script, sorry.
Sure.
If it really is, as you say, only a few jurisdictions, why not make the program voluntary?
Well, because our mission is to enforce the immigration laws nationally, and one of the ways we do that is by identifying, people who are in state and local custody and have been arrested and convicted of crimes. And there is no local role in this program. Part of the price of membership, if you will, in the FBI club in terms of having access to CJIS, which you see on your, and IAFIS, which you see on your handout, is that by participating in those programs, you agree to share your fingerprints with other legitimate law enforcement agencies. And so if Nassau County participates in that system, which they do, by participating, they cannot say that we don't want Suffolk County to see our fingerprints, that we don't want the Marshal Service to see our fingerprints. That is the price of admission. And so there's nothing voluntary about our getting their prints. It's the way the program works. Now, a jurisdiction can determine what prints they send, and in some states they send certain levels of crimes and not others. They certainly have the right to do that. But once they decide to participate in the FBI program, they in effect lose control of their prints. So there's nothing voluntary or involuntary other than choosing not to participate at all.
So I'd like to actually come back to that in a moment, this piece, because I think there has been, definitely a lot of discourse about the mandatory aspect of the program, right? But is there anything that you want to share before that related to, who has been deported under secure communities?
Sure. Since secure communities started in 2008, we have removed approximately 140,000 people. Of the 140,000, 95% have fallen into one of the priority categories I mentioned: criminal aliens, fugitives, repeat offenders. And
Can you differentiate between those different groups of the 95%? Like what percentage are?
about 70% of those were people convicted of crimes, criminal offenders.
So they've all had convictions?
Yes. So about 100,000 of the 140,000 had criminal convictions. Within that group, roughly 60,000 were felons. About 40,000 were misdemeanors. And within the misdemeanors, you have, I can't remember exactly, but probably 20,000, maybe more, DUI cases, drug cases, things like that.
And the felony cases, so those, what types of crimes are we looking at?
Your typical felonies. I mean, they could be sexual assaults, they could be armed robbery, they could be kidnapping. I mean, whatever felonies people get arrested for in the 50 states. And, of the 40,000 that were not criminals, that's where you have fugitives, repeat offenders, and
what are fugitives?
A fugitive is not what you typically think from TV. An ICE fugitive is someone who has been ordered removed from the country and then absconded rather than leave. So.
And were any of these individuals, do they have prior criminal convictions?
They could, but to become an ICE fugitive and placed into that category, they don't have to have a criminal conviction.
Okay.
And when you get down to the sort of the bottom of it, there were 8,000 people removed so far who were not in one of those priority categories and were, in effect, just here in violation of the immigration laws, and that's why they were removed.
So can you talk about, so the DHS has restated support for prosecutorial discretion, and can you talk about how ICE officials are using it and in what circumstances and how this might reconcile against the stated priorities for removal?
Sure. As I said earlier, we have the 4 priorities. We removed 396,000 people last year, and about 90% of those 396 fell into one of the priority categories. 216,000 of the 396 were convicted criminals. So we've got 10% that do not fall.
So that's where prosecutorial discretion would be?
That's one of the places where we believe we can be looking at prosecutorial discretion to focus our resources on the priorities. We are looking at using prosecutorial discretion to close some of the 300,000 active cases in immigration court to free up resources so that we can devote those resources to the priorities. And we use prosecutorial discretion throughout the immigration continuum. Even if someone has been placed into immigration proceedings, we use discretion to decide who is detained and who isn't. We use discretion to decide who is actually removed and who isn't in terms of granting stays and deferrals. So prosecutorial discretion is a broad term that refers not only to who is initially apprehended, but who's detained, who isn't, and who's ultimately removed. So we apply it throughout the process.
So this is, you guys have been doing this for some time. It's not like anything is changing with, there seems like there's been kind of more press coverage of the fact that DHS is doing this, and I know John Morton.
Well, like any law enforcement agency or any law enforcement system, there's always been prosecutorial discretion. I think what's different is that we are trying to use it to focus on, key priorities that make sense from an immigration enforcement standpoint, and to formalize it a little bit more than it has been, because I don't know if you've seen Director Morton's memo, which is on the website. He lists, 10, 15, 20 prior memos all dealing with different parts of it, and so now we have a single document that is the source for guidance on prosecutorial discretion.
Okay. And then one more question for you, Gary. How does ICE keep track of crime victims and other vulnerable populations, for example, victims of trafficking, in the data that is collected through secure communities?
I don't believe that secure communities in and of itself tracks that. We track in our immigration database that ICE uses the nature of what individuals may have experienced. But secure communities itself is only, as you've got on your piece of paper here, criminal fingerprints being compared against immigration databases and matches, which is an important point. You know, secure communities has become bigger than it really is. It is just information sharing. It is not black trucks with people in SWAT outfits cruising the streets, scooping people up. It is just information sharing. The information is then used, as we use all other leads, to determine what, if any, action should be taken.
Okay, thank you. Sunita, can you talk about how, you know, the stated priorities and what Gary has shared address some of the concerns that advocates have been raising? I know that there was a report that was recently issued by the Warren Institute that discussed due process concerns. Can you talk about this?
Sure. I mean, I think that one thing to keep in mind is that it's very easy to say that the stated priorities, that you've reached 95% of the stated priorities if you're in control of deciding what the priorities are and defining what fits in those priorities. So just to respond briefly, one of the issues that we've seen throughout this program's inception and from the time that data became publicly available, which again was only after litigation since July 2010, is that the data that's being provided to the public, when it is provided, it doesn't really match up with this idea of what the priorities are. So when the priorities were, and the priorities keep shifting, so when the priorities were, you know, locating the worst criminal offenders, there was a priority list that included the NCIC database and criminal charges, and then there was this complicated level 1, 2, and 3 system. And now we're hearing that the stated priorities basically include everyone, anyone who's here without who's entered without inspection, anyone with some kind of encounter with law enforcement, anyone who didn't leave the country after having a removal order. So it's pretty easy to show that you've met all of your priorities. I mean, the real question is, who are the people that are not in those priorities who you're removing? And honestly, and you know, I think one of the things that we've stressed is that if the government's going to stand behind these statistics that they're putting out, will they release the underlying data so that statisticians, researchers, and all of us, all of the public, can actually test and figure out if what they're saying is actually the truth? Because we know that when it comes to this program, there has been quite a bit of misinformation and confusion, to be generous to ICE. So in terms of the report, we were able to receive quite a bit of a sample of data that is basically covers a random sample of everyone who's been detected and apprehended through secure communities. And the Warren Institute published a report with some pretty interesting findings that relate to due process concerns. So ICE and DHS often talk about the priorities and the who is being removed in terms of one feature, which is the level of criminal offense. But we also know that these are real people with families and ties to the community. And this report showed, I'm just going to run off a few statistics, that more than a third, 39% of non-citizens arrested through secure communities have U.S. citizen spouses and children. That means, if you extrapolate this out, 88,000 families with U.S. citizens have been impacted by secure communities. A little over half of people who've been in removal proceedings because of secure communities only half were provided court hearings. And of those, only 25% had attorneys. Especially given the impact that this has on citizens and people with family ties in the United States. I mean, this is an astounding number. Only 25% of people who had immigration hearings had access to lawyers, and that only half of the people who were deported through secure communities even had a court hearing. Almost half of the people who were deported in the sample were transferred at least one time. One person was transferred 10 times in 5 months, and we can imagine for people who do immigration work, you know that when we say someone is transferred in immigration custody, it means they could potentially end up in Texas or Louisiana if they're from New York. So they're very far away from their social networks, from their community ties, and really from access to lawyers and resources to help defend their case. And when they're in detention detention and transferred, it makes it a lot easier for immigration enforcement to make their case, because it's harder for the person to access information, and they're less likely to fight cases, even when they have valid claims of relief. And then, just finally, one of the numbers that I thought was very interesting was that 77% of the undocumented population is Latinos in the United States, but 93% of the arrests in Escom were Hispanic and Latinos. That's an astounding number, given the indicia of racial profiling that this program is generating in jurisdictions, especially those jurisdictions with heavy anti-immigrant sentiment. I think that number tells us a lot. So I would just say to Gary and to folks at ICE, if you want to stand behind your numbers, release the underlying data so we can test it.
I'd like to bring in Peter now. Peter, can you talk about your views, particularly in response to the due process concerns that Sunita raised?
Sure. And before I do, I want to thank the New York Law School and Vera for convening this conference on a very important program. My position is that for the whatever flaws there are in the program, the sensible response is to mend it, not end it, to use a phrase that I did not make up. And that is because it is senseless not to exploit the databases that now exist if we're serious about identifying criminal aliens who are in the system, who are in custody at the state and local level, who may or may not be removable, or those who have violated immigration laws, do not have a criminal record, but are candidates for removability. To deny access and use of this very valuable database, it just makes no sense at all. So I think there's certainly criticisms to be leveled at the program, and Sunita has identified some. I think Gary will respond and tell us to what extent those accusations are accurate. But to opt out of the program entirely, as 3 states have, it seems to me quite irresponsible and can only be explained in terms of political considerations in those states. So I want to make a couple of broader points that it seems to me are important in understanding and assessing this program. The first of all, immigration reform is an imperative that we have been seeking for many years. It has not happened. It did not happen. It is not happening under the current administration. It did not happen when the Democrats controlled Congress in 2009, 2010. I doubt that it will happen in the next couple of years because of a variety of factors. So the point of this is that while there are many reforms of the immigration enforcement process that we might favor, and I certainly favor a generous legalization program, increased legal visas for Mexicans, and a variety of other changes, that's not a basis for criticizing the Secure Communities program. Secure Communities program exists now. It's dealing with a problem under existing law, and the purpose is to enforce the existing law effectively. That leads me to a second point, which is that I believe firmly, after having studied immigration policy for a very long time, that as a political matter, the only way we can assure a generous legal immigration policy, a liberal legal immigration policy, is if we do the best we can to make the enforcement process work effectively. This is not the task of advocates who are representing their clients and understandably, indeed ethically, are required to do the best they can to prevent their clients from being removed, and more power to them. But it is the job of citizens and politicians and policymakers and others who have to make sure that the system works effectively so that the public will support a generous legal immigration policy. in a program like this, mistakes are bound to be made. We're talking about very large numbers of people, and it doesn't surprise me that Sunita and other advocates can point to some horrendous cases, and those cases ought to be remedied. And but to stigmatize a program simply because some mistakes happen when you're dealing with very large numbers is, I think, a mistake. The idea, again, is to improve the program, not to discredit it and eliminate it. And of course, the people who come into the secure communities databases are going to be disproportionately Hispanic, whether simply by reason of the demographic characteristics of the population that's taking into custody, and whether it's disproportionate, as Sunita has suggested, is a question I think we can't answer simply by looking at the disparity between 90% and 75%, whatever the question was. It's an important question, but it's not one that can be resolved that way. Finally, I want to correct one point that Gary made, which is he assured us that the state and localities do not have to spend any of their resources on the program, and that's true, but they do have to incur some expenses when they detain immigrants for the 48 hours pursuant to detainers issued by ICE. He said that those expenses can be reimbursed, and indeed they can be reimbursed if Congress would fund the SCAP program, but Congress has not funded the SCAP program adequately. So it ends up costing state and localities a fair amount of money to process, not necessarily because of secure communities, but to process criminal aliens, which the federal government ought to be bearing rather than the states and localities. This is a serious discrepancy between the costs that are incurred and the costs that are reimbursed by the federal government. In terms of due process concerns, I think one needs to look very carefully at the actual processes that are used, the facts of the cases that are alleged to be improper, and I can't speak to that except that due process is, of course, sacred in our society and must be observed. And if the program is violating it, then so much the worse for the program, and it has to be corrected.
Okay, thank you. So I'd like to come back now to this question of the mandatory program. So, some of you may be aware that just a few days ago, a New York District Court judge ruled that ICE turn over a memo, essentially, that discussed their decision-making around the program. There was also a Homeland Security Task Force on security communities that was convened primarily over the summer that also noted that there was a misunderstanding around memorandums of agreement with states and localities, and that DHS changed its position about whether they could terminate their participation. Gary, can you talk about what it looks like as being a change in the position of ICE around the participation in the program?
Yeah, and I think we're actually moving to a very important point in the discussion tonight, which is the concern about secure communities, or is the concern about our immigration laws? Because virtually none of the things that Sunita mentioned, transfers, access to attorneys, whether or not having a family member or family or any other equity should prevent someone from being removed from the United States. None of that is a secure communities function. Secure communities did not create those issues. Secure communities is just information sharing. It gets down to whether or not people in immigration proceedings, like people in criminal proceedings, should have a right to an attorney, and one be provided if they can't afford it. The immigration laws do not provide for that. That has nothing to do with secure communities. Whether or not a family member or other equity should prevent removal. That's not a secure communities issue, that's an immigration law issue. So I think that's,
But Gary, do you agree that that's a problem?
it's a problem with all of immigration enforcement.
So why would you rapidly expand a program and expand immigration enforcement in such a record number if you know there are problems and there isn't an end in sight in terms of correcting them?
Well, because we are sworn to enforce the laws as they're written, and I think the President and the Secretary and the Director and most of us in ICE would be or have been on record as saying the immigration laws need to be amended, and they don't work for us, and they do some things that I'm sure some of us would rather not do, but those are the laws we have.
Gary, can I ask you a question? So without secure communities, would ICE be able to deport 400,000 individuals with their current level of resources?
They always were. If you go back 3 years and look at the numbers, we have been, near 400,000. I think in 2008 we may have been around 370, 380.
But secure communities started in 2008. Right. So before 2008, were the numbers that high?
No, they were lower going back because our resources were lower. But what you see since secure communities is a dramatic change in who we are removing. If you get back to 2008, we removed more non-criminals than criminals. Last year, for the first time, 2010, we were at 50-50. This year, we are at about 55% criminal, 45% non-criminal. So secure communities has helped with that. The CAP program, criminal alien program, has helped with that. But it's just a further example of the priorities working.
Just to be clear, though, in terms of just the piece about criminals, so in the priorities are individuals that have been charged or convicted with illegal reentry. Now, is that the only is that the crime, reentering, or is there because?
No, the 210,000 people that we talk about are not people that have been charged with crimes. Those are people who have been convicted of crimes. And the overwhelming majority of them are people who have been convicted of state and local.
So not immigration?
No. Being here illegally is not one of those crimes. Now, we are aggressively prosecuting people for felony offenses, federal felony offenses, who are illegal reentrants. And we last year prosecuted about 10,000 of those people. But generally speaking, when we talk about criminal aliens, those are people who have been convicted on state and local criminal charges. Okay. Getting to the mandatory question, and that's a long, drawn-out way to get there. I can only go back to what I said at the beginning and what others have said. We have badly messaged this program. I think the request from Congress was actually a directive from Congress in 2008 to find a way to enhance our criminal alien program was clear, and we took advantage of two things that already existed. One was the historic process of submitting fingerprints to the FBI, and an act of Congress which told the federal government it had to share criminal information with the Department of Homeland Security for the purpose of identifying removable aliens. Those two things were there. We looked at different options as to how we could carry out the congressional mandate. One was to go back to Congress and say, give us, I don't remember the number, but give us thousands of more immigration officers, and we will be in every jail in the country 24/7.
So the mandatory aspect of it was about resources?
The mandatory aspect of it was Congress directed us to find a way to enhance the criminal alien program, to identify people convicted of crimes in this country. We looked at many options. The simplest and we thought most effective was to do it through information sharing. Take the prints that were submitted from the FBI or submitted to the FBI and compare those to the immigration databases. So we did not have any choice in terms of finding a way to enhance the criminal alien program. We were directed to do that. This is the system we came up with. We think it's the right answer as compared to adding, potentially thousands more employees to do the same thing, but, actually in the jails. Okay.
And Sunita, can you just, talk about, what the advocates have been working on with regard to the opt-out and mandatory kind of nature of secure communities, and feel free to provide just a tad bit of detailed, but recognize that we're a little bit short on time.
Sure. Well, I just wanted to again, Gary's pointing to statistics that when we look behind them, the truth really comes out. I mean, the idea of criminal and non-criminal within the ICE statistics and in their data has changed over time. So yes, it's true that the statistics that they are putting out show an increase in the number of people who are categorized as quote-unquote criminals. The criminals includes people who have entered without a visa and includes traffic offenses. We don't know all of the details of how they're categorizing what is included as a quote-unquote criminal and criminal charges within this list that hasn't been disclosed. So again, I would urge ICE to release the specific data and the information behind the statistics that they keep putting out instead of spinning numbers to put forward the idea that they are protecting the community and this vague notion of public safety that we all know is often used in order to encourage the public to agree with government initiatives that have to do with law enforcement. But I think it's important to note that the task force that Susan mentioned is a task force of people that DHS and ICE hand-selected the people in that task force, and their draft report that was released clearly says that the program has serious flaws. Some people even said that the public relations, has been mismanaged in such a way that the program should be completely scrapped. There was a recommendation that it should be suspended while there are changes being made, and so the idea that this program should just continue forward because of because of the immigration law rings a little bit hollow, especially when Gary just mentioned the use of prosecutorial discretion. So we know that at the same time as they say they must enforce the law, they also are willing to exercise prosecutorial discretion. And I also, just in terms of answering the question about the mandatory program, I think that this is not just a messaging issue. This was not just a poorly messaged program. This is a program where the policy around the mandatory nature of the program has changed over time. I have read emails between ICE officials, the FBI, and local law enforcement where they have made it very clear to local law enforcement that they will not be forced into this program. They have spent months and I can't even imagine how much money they've spent trying to cajole states into signing agreements that govern the information sharing between ICE and DHS and the states. I don't really understand why they would bother doing that if in reality this is really just about information sharing between the federal government. This agreements between the states and CJIS, the FBI Criminal Justice Information Service, does not say that that information is going to be shared with the Department of Homeland Security. That is, these agreements predate secure communities, and many states have decided themselves that they don't think that this is a very good idea and that they don't want to participate, and that's an important consideration. And although it's 3 states and supposedly only a few jurisdictions, those jurisdictions are the ones that ICE has prioritized enrollment in secure communities because they have high immigrant populations, and that's important to recognize as well.
So I'd like to just recognize, maybe want to have some time for all of your questions. Let's move to the effect of this immigration enforcement strategy on the criminal justice system. District Attorney Soares, can you talk about the impact on criminal investigations?
Well, first and foremost, let me just say that I happen to be very fortunate to be in Albany County, and we have a wonderful working relationship with the investigators from ICE, and they're doing a very good job in Albany County. So if you're doing any memos to follow that. But it does, quite frankly, the immigration issue is a dark cloud that hangs over investigations, especially when we have victims of crime that belong to what I would consider the shadow population. Our southern portion of our community, we have a lot of farms, and we have individuals that are employed there, and quite frankly, in terms of our cases, they run all across the spectrum, but it adds a tremendous level of difficulty when we are trying to get a victim of crime to come forward and to assist us in a prosecution by cooperating. There's a lot of pressure that's foisted upon that individual by the community, and they also feel this pressure from the immigration process as well. But in terms of the relationship with ICE and the immigration that relates to our cases, I've seen the good, the bad, and the ugly.
So what is your thought on, I mean, Gary had noted that they haven't seen any complaints with regard, to victims coming forward or, victim witness cooperation. I mean, so are you seeing problems or?
Oh, well, quite frankly, I mean, we had a case not too long ago where, a 13-year-old who happened to be in school, and the nurses observed her getting a little heavier, and turned out she was pregnant, and they hotlined the young lady, and the CPS began an investigation. ICE was also brought into the picture, and we had a difficult time actually locating our victim because the community kept on shifting her around from different communities, making an effort to hide her from us, and we eventually, located her, and but there was just such difficulty in trying to convince the family and to convince the community that, listen, we're on our side and we're trying to seek justice for the young lady.
How often does this happen?
It happens more often than we'd like to think, and quite frankly, what we have more often than not are people not coming forward and reporting crimes. We have a number of individuals. Look, we have criminals in the streets that are predators. They will strike upon a population that they feel are vulnerable if there's benefits to be had there. And what we have are individuals who are undocumented, who are working, and they're being paid cash, and they're easy targets, but they will not cooperate and come forward and report. So it makes it difficult. On the other hand, we do have instances where some of our criminals are people who are not here legally in the country, and they perpetrate some of the most horrific crimes, and we reach out to ICE, and ICE provides us with support, and we as prosecutors feel great knowing that we're holding that offender accountable. They're paying their debt to society, but then we can also feel good in telling that victim that person's not going to be bothering you anymore.
And what about just thinking that you're in Albany County, and I feel like resources and government resources are a big topic probably all the time. I mean, can you talk about, there's been comments made during, in the panel of resources, the cost to states, the cost to localities. What are your thoughts in terms of the resources that are required for a program such as this?
Well, there are resources that are taxing the local communities. I mean, and they may not just come in the form of housing individuals. I can tell you that I do a lot of hand-wringing, and there's a lot of stress and time that we spend in dealing with cases where we have victims that are undocumented. And we have those issues too with defendants that quite frankly commit low-level offenses, but the collateral consequences of the offense are so unjust. And so, exercising prosecutorial discretion to ensure that what they're going to be held accountable for is exactly what they did, and not have to have people, being deported back to Nigeria because of an e-felony larceny.
Mm-hmm. Okay. So I encourage you all to write questions. I can't tell if you guys have been actively writing, but please do write questions. And I'd like to just close with one question that I'll ask and then open it up to you. So let's just go back to the title of this event. Is secure communities the best immigration enforcement strategy to keep communities safe? Peter?
Well, I think, as I said before, that any strategy to be effective has to rely upon the information that we have and integrate the databases concerning criminal conduct that are maintained by the FBI and immigration status that are maintained by DHS, and put those databases together. What happens after that is a real question. Gary's explained the priorities that have been put in place, and Sunita has said the priorities aren't really being observed. number of situations in which people are being deported who we might think would have very strong equities not to be deported. But again, as I emphasized, the fact that many undocumented immigrants in the United States are fearful and are reluctant to cooperate with the police is a function of our current immigration laws, and it's not secure communities has to deal with immigrants as it finds them, and the fact that many of them should have legal status under any sensible legalization program is sort of irrelevant once you accept the premise that secure communities has to enforce the law as it sees as it finds it, and there are a lot of very serious crimes being committed by non-citizens, and there's simply no way to enforce that law effectively without putting these databases together and then exercising prosecutorial discretion in a sensible manner.
And Sunita?
Well, I wanted to close with a little bit of a story, but, you know, just keep in mind that the criminal justice system is there to deal with serious crimes, not the immigration system. It's supposed to be a separate system. So in closing, I'd like to tell you a story about a 17-year-old boy who fled to Boston following persecution, after persecution and forced labor. He lived there and worked in Boston as a bricklayer and doing odd jobs. One day, Tomas was arrested and put in jail on a false charge of theft. The charge was ultimately dropped. Even so, Boston police turned Thomas over to federal authorities and he was detained. There were strong protests by advocates for his release. However, he was sent back to where he came from, and upon his return, Thomas was immediately imprisoned and physically abused. This is the true story of Thomas Sims, not a victim of the modern-day immigration enforcement system, but an escaped slave who went north only to be returned to Georgia in 1851 with the assistance of local police. And I didn't tell you that story to analogize immigration with slavery at all, or to blame the Boston police for their role. But let's think about the historical scenario. In 1793, the government passed a Fugitive Slave Law that essentially allowed participation of state authorities in the capture of so-called fugitive slaves. Following the passage of this law, which basically encouraged states and localities to participate in sending back fugitive slaves, states like New York, Massachusetts, and Illinois felt a moral and a political obligation to not participate in the Fugitive Slave Law. They wanted to opt out of the program, out of this law. The states passed local personal liberty laws, and this allowed them to limit the participation in sending back slaves. In response to the outcry by some of the states, the federal government changed the rules. It passed another law, the Fugitive Slave Law of 1850, which made cooperation in the capture of escaped slaves essentially mandatory. This led black people like Thomas Sims to be held in federal or state custody, often without access to attorneys or the ability to plead their case before a judge. Does this sound familiar to anybody else, like the opt-out situation? With the Fugitive Slave Law of 1850, federal authorities tried to compel local police to take responsibility for the capture and expulsion of a group of people that they deemed undesirable. Communities were upset and states resisted on political and moral grounds. It's interesting to note, though, that even after 1850, with the passage of the law, which again tried to compel states and local authorities to participate in sending back slaves to the South, local governments continued to resist, and the public kept up the pressure. In Chicago, the Common Council called the law unconstitutional and refused to require city police to assist in the cooperation with the federal government. And the Vermont legislature attempted to nullify the statute. Boston police questioned its legitimacy, and lots of citizens broke free, detained fugitive slaves, and helped them go to Canada. So I think the question here is, what are we going to do here with this program that's being unveiled as a mandatory program, and in which citizens and states and lots of the public there's a large outcry against this program, but yet the federal government is still trying to force everyone to participate.
Thank you. So I have enough questions here to keep us until 8 a.m. I hope you guys realize that that's when this is ending.
Do I get a final comment? Yeah, fair is fair. Thank you. Okay, just a couple things. There is no one in the room who would like to see immigration reform more than me, and I would encourage you to go back to this handout, which I didn't do, but it accurately portrays what Secure Communities is. Most of the criticisms you've heard about Secure Communities are not criticisms of Secure Communities. They are criticisms of the immigration process we find ourselves with, and that process should be reformed. The immigration priorities are not vague. They are not recent. They go back over a year. They're straightforward, easy to understand. The criminal alien definition is straightforward. It's someone who's here unlawfully and has been convicted of another crime. Does this priority make America safe? 210,000 people are not here today that were here last year. Those 210,000 people, if you believe recidivism rates, would within 3 years potentially commit, 50%, 60% of them would commit another crime. So I would argue that that certainly makes America safer. In terms of, again, the level of criticism about the program, the criticism is, well-intentioned and is correct in many areas, certainly about the messaging, certainly how we need to find a better way to deal with people who are just low-level offenders. There's no question that we need to find a better way to deal with that. But the overwhelming majority of the communities that participate in Secure Communities not only have not voiced any concerns, but they welcome the program.
Gary, I have a question for you. The second question is for you, so we'll come back to you in one moment. But I have a question for Peter. So ICE's Escom webpage says that only 28,000 of the 77,000 non-citizens removed as a result of Escom had level 1, i.e. the most serious convictions. Isn't it a misallocation of resources for ICE to employ 2/3 of this program's resources for non-citizens with low level or no convictions? Peter?
Well, I think I'd want to know more about those cases. It may well be the case that these folks should be the beneficiaries of prosecutorial discretion and not be removed, but some of them may constitute a danger to the society. You'd have to look at each case.
Okay, this is a question for Gary. ICE has stated that the Escom program is mainly about information sharing at the federal level. However, even high-ranking officials at the FBI have publicly stated that states and localities are the owners of the data they provide to the FBI and thus have control over use of this data. How can the federal government use a state's data if the state doesn't authorize it? How can the federal government force states, localities who wish to opt out to share data?
Yeah, I'm not, familiar with exactly where that comes from, but yes, state and local governments are the controllers of the data. They are responsible for its accuracy. They're responsible for updating it. Absolutely. But again, once the data ends up in IAFIS, it is shareable with any other participant. As I said, New York State cannot say, we're not going to share our data with Connecticut. New York State cannot say, we're not going to share our data with the Marshal Service or DEA or FBI as an entity, in addition to being the holder of the data. It is the price of participating. And there is a federal statute that clearly says any criminal information in the possession of federal agencies must be shared with the Department of Homeland Security for the purpose of determining the removability of persons.
And what is that statute?
Give me a second.
I think somewhere. I think, quite frankly, look, we're 2011. There's information sharing going on everywhere. I think it's absurd to talk about whether we should or shouldn't. The fact of the matter is that it is being shared. The FBI, the FBI maintain a lot of the statistics for all law enforcement. They measure crime trends, and in order to measure crime trends, local jurisdictions, participate by providing that information. In addition to the fact that there are a number of grants that local law enforcement receive, including DA's offices and police departments, that part of those, what comes with those grants is you have to return that information to the FBI so that they can.
So David, is that within solely the criminal justice system, or are you also talking about, the immigration system, which is not?
I'm talking about the criminal justice system, and if that information is being turned over to the FBI because of either compliance with a grant or something else, that information eventually is going to get into the hands of the immigration system. But I think that there were some valid points that were being made here. Now, I'm not looking for brownie points here for the people that I work with in Albany, but these are compassionate people. These are people that get it. I mean, they're working and they're laboring under this law that some of them don't agree with. I will not mention any names, but when we're in discussions and we're working together and we're trying to arrive or achieve a goal, they get it. They educate us about processes that can avoid triggering some of those outcomes that I think we all don't like seeing here. In my case, where we had the 13-year-old girl who was pregnant hidden from us in a community that didn't want to participate with us, we ultimately held the offender accountable. We sent him to prison, but at the end of the story, that person was deported, back to his country, and the girl was sent back to go live with them because the family wasn't going to take care of the child that was born. But we have to figure out how to get a better immigration policy and sort of relieve some of these agents from operating under the process that they're operating right now.
So David, I have a question for you that was posed by the audience. So as a law enforcement official, you know that the Fourth Amendment forbids arresting people without probable cause. But ICE holds people in local jails for up to 48 hours, excluding weekends, on detainers, according to ICE's website, to allow for an interview of the person to see if he, in fact, is removable. This is how some citizens get held on detainers. Is holding people in jail for 2 to 5 days on a holiday weekend without knowing whether they are removable consistent with the Fourth Amendment and due process of law?
Who asked me that question?
There's some law students.
It must have been a law student.
Oh, man. Look, the fact that someone is here illegally, and there's some evidence of that fact, I think would lend itself to probable cause to detain a person for, what would be perceived, even though 2 or 3 days, would be perceived as I know 2 or 3 days is 2 or 3 long days, but I do think that the courts would find it reasonable. I know for a fact that there are instances where people are being held, for example, when we're talking about bail applications, do you have any local ties to a community? Is one of the prime, issues that a question that a judge will ask. And even though it's a lower level offense, something that, your citizen would be allowed to, get bail set or be released in their own recognizance, I do know that there are people that are not being afforded that same opportunity, and that's wrong, but it's happening.
Do you think that looking at local ties to the community is something that should factor into the priorities?
Local ties to a community is one of the, prime, elements for considering, release for an offender, and it's something that we do in every instance. So I do think that it's an important element because we want to make sure that that person returns and completes the process, the due process that they're being afforded in the system.
Okay. This is a question for Sunita. Doesn't prosecutorial discretion help correct for some of the concerns that you've raised with secure communities?
I would say it doesn't, but I actually, there's if it's okay, there's someone here who's working on this issue in New York and around the country who's here that would probably be able to answer this question better.
Yeah, and who is that?
Josh Epstein works at the Immigrant Defense Project.
Thank you.
Yeah.
And thank you, Sunita. So I work at the Immigrant Defense Project, and at the Immigrant Defense Project, we run a hotline that receives about 2,000 calls a year and dozens of calls each day. And through those calls and through our national partners, we realized that prosecutorial discretion and the prosecutorial discretion memo that recently came out is way too limiting. and excludes many, many people, and thus families and communities are destroyed. And it is a little unfortunate that in response to various states pushing back against secure communities, that prosecutorial discretion was the answer. Because as we were talking about before, it really isn't a new policy. It was just a restatement of an already existing ICE policy. And as part of the New York State Working Group Against Deportation, and I know that a few organizations here today represent that working group, we would all like to call on ICE to respect the decisions of New York State and other states to opt out of secure communities permanently.
How would you expand the prosecutorial discretion guidance that's out there?
For one, it should not exclude everyone with criminal convictions.
It doesn't.
But criminal convictions is a huge area where, along with the priorities that are stated, right? And going back to something about the priorities that were stated, so you were talking about felonies before.
But let's stick with that. How would you change the prosecutorial discretion guidance? We'd be interested in hearing. I mean, it calls for a case-by-case review. It gives some guidelines, but it doesn't exclude anyone out or include anyone in as a class. So what would you do differently?
I agree with that the memo doesn't do that. From all the experiences that we've seen and from all the cases that we've seen, no one with criminal convictions, despite living in the country for decades, having family here, long ties to the community, has received prosecutorial discretion.
So you're saying the policy doesn't match the practice?
Absolutely.
Can you point to anyone with a criminal conviction who's been granted prosecutorial discretion?
Sure. I mean, we have cases all the time that get out on bond with prosecutorial discretion who have criminal convictions. We get people who have criminal convictions and get deferred action and stays. We've had situations involving ICE fugitives who get deferred action and stays.
Can you just explain what deferred action is for anyone who doesn't know?
It's a situation where someone has a final order of removal, and for good and sufficient reason, we will defer removing them from the country to give them opportunities to resolve any number of issues. I mean,
But can they work?
Number of people who've been granted deferred action in the last year, or who've been granted prosecutorial discretion?
I think we had, in terms of deferred action, I'm not going to just give you a number because it'll be quoted as a fact, but
Because it's rarely granted.
No, I don't think that's true. I don't think that's true at all.
But we'd welcome that information.
Okay. But again, if you have any ideas on how we could improve the prosecutorial discretion guidance, we'd very much be interested in hearing that.
I think one of the issues we were talking about before was that the policy and the guidance don't match what's happening on the ground. So there's a huge discrepancy there.
And if you could, bring us, cases or bring them to the field office here in Manhattan, I'm sure they'd be happy to look at them and explain what they did and why they did it.
And just, working at the Vera Institute, I feel like I need to say this, that we always welcome data being out there and looking at the data. And so it seems like, that would be just an interesting, I think, area if you're going to be releasing data to be sharing that information. Okay, so this is a question for Gary. What is ICE doing to address or mitigate the negative effect Escom has on positive community policing efforts, and that domestic violence survivors and other victims of crime are reluctant to report crimes? And I know that you indicated that you hadn't yet had any, numbers or reports come forward, but, just taking into account what District Attorney Soares said, are there any initiatives?
We're actually doing a number of things. We are promoting the information that's on the new website. We are working with the Department of Homeland Security Civil Rights and Civil Liberties Office to produce a series of DVDs to go out to the community to explain the program, to explain the various protections for victims and witnesses. We have set up a new complaint process. We are about to launch a statistical model, which you can also see on the website, that will be used as an early warning system to tell us that a jurisdiction might be abusing secure communities, so that we could, through the Office of CRCL, investigate that. We're doing as much as we can to attend meetings like this to be able to answer questions about what the program is and isn't. So, I think we're doing a lot in that regard. As I said, the prosecutorial discretion memo was aimed at helping with some of this. It had the companion memo on protections for victims and witnesses of crime, and we're continuing to solicit input. It was Director Morton who asked for the task force to study secure communities. No one told us to do that. That was something he asked for, and we're reviewing their recommendations now, and I'm sure many of them we will implement.
Yeah, can you just provide an update? I think the latest that has been publicized is that it's being considered by the Secretary. Is there a time frame, or what are the next steps with that report?
I've not heard her mention a time frame, but we also have a copy, and we're going through it.
Okay. Peter, did you have a comment related to this?
Yes, I want to make a point about some of the complexities of administering a law like this that need to be taken into account in determining whether it's being abused. Two phrases that have been used a lot for perfectly understandable reasons are low-level offenses and community ties. Low level is very much in the eye of the beholder, and particularly when you consider that given our system of criminal justice in the United States, offenses that are committed are often broken down into much less serious offenses in order to induce plea bargains and for other reasons. And so we know that a very substantial percentage of drug trafficking offenses are broken down to drug possession offenses. And whether you consider drug possession a low-level offense or not is obviously in the mind of the assessor, but I think that's an important consideration. And secondly, in connection with community ties, there are community ties that are obviously compelling, such as having citizen children, but there are other community ties that are less compelling, like having a job, having friends, having been in the country for a certain period of time. So this all means that it's very important to look on a case-by-case basis at the way in which these categories are being actually defined and implemented.
Okay.
I would agree with that. I know what we've started to see in New York State, and this is an issue probably over the last 5 years. I've seen the defense bar do a much better job in articulating some of the collateral consequences of certain pleas, but I can tell you that we're talking about the defense bar. I just noticed you go like this. The defense bar, more recently, doing a better job of engaging, DAs in conversation about the collateral consequences of certain pleas, and so they're better educated at this point. But I recall, 10 years ago, there were attorneys coming in and taking pleas where because I'm an immigrant, I came here when I was 6 years old, I would say, are you sure about this? Is it going to trigger, a collateral consequence with their status? They go, oh, no, that's fine. But what that's done is it's caused for more motions to come back to us where, we're being asked to reconsider the plea, vacate, the plea, or reopen a case that's already been resolved because it's triggered the ICE action. And that's something that we're seeing the criminal justice being inundated with.
That's a
I
very
think I'd just
important
like to make
point.
one.
It's not a secure communities issue, but we have just, over the past 2 months, opened a dialogue with representatives of the defense bar and public defenders to figure out if there are ways we can do some things differently to mitigate those adverse impacts. Because you're right, there are situations where a pending immigration action can influence whether or not someone gets bond or whether or not someone gets treatment programs or someone gets other programming, within state and local systems. So we are working, as I said, with the defense bar and public defenders to see what we can do a little differently. And if any of you are working with groups like that, we'd be very interested in hearing your thoughts on how we could mitigate some of those impacts.
Well, but if what you're saying, Peter, is that there needs to be a case-by-case review, and it seems to be, David, what you're suggesting as well, then it doesn't make sense for secure communities to be mandatory or for secure communities to be there at all, because that is a program that requires information sharing and gives immigration enforcement all the information on the person to take action. It's not a discretionary program. It's not CAP, where the person goes and gets interviewed, and there is some person-to-person contact, and there's a decision being made by a human being. So I think
those are two separate questions. Whether a program is mandatory or not is very different than the question as to which people who are eligible for removal by reason of their having committed crimes ought to be removed or ought instead to be given prosecutorial discretion to remain. It's an entirely separate question.
I would just offer up something, to Homeland Security, and that is, we really need to change the perception of ICE and Homeland Security amongst the community, because I can't imagine living in a community where they would rather have a rapist or a person who's engaging in domestic violence live amongst them than report, a crime for fear of being deported. And that's what we have. We have communities that are so insulated because of the fear of the immigration issue that they will, put up with abuse, and that's something we've got to change.
And that is exactly why ICE and law enforcement should not be getting in the business of immigration enforcement. And for the Department of Homeland Security to take the position that this is the most cost-effective, safe way to do it, it's because they want to stop. They don't want anyone to see the black vans going in the neighborhoods and rounding people up. They just let the law enforcement do that legally or illegally, and then they take action once the person's already behind bars. And I think we have a really serious problem with that, especially in a place like New York City, where there's a serious epidemic of stop and frisk and unlawful Fourth Amendment and 14th Amendment violations happening against Black and Latino New Yorkers. There was an incident where there was a non-citizen who was getting stopped by a police officer in the subway and ran because this person was very afraid that there would be an immigration encounter after because of being questioned by the police, and that person was tasered. So we're talking about an escalation scenario here where, yes, there's several people on this panel who talk about a case-by-case scenario, and, well, I don't know the facts of that situation, but the reality is these, what are called anecdotal information, it's not a one-off instance. It happens over and over again. There's many reports of these problems, and it's really time for ICE to take the concerns of the community seriously and listen to what the public is saying. This program needs to be suspended. It needs to be terminated, and especially in locations with a history and a record of racial profiling. I mean, the Department of Justice Civil Rights Division is investigating lots of jurisdictions for police abuse, and yet the Secure Communities program is still operating in those jurisdictions. I think there is a serious double standard that's happening for non-citizens in those jurisdictions.
So we are out of time, but I want to end with kind of with a bang, I guess. But there were a lot of questions in this stack dealing with racial profiling, which I think just very much relates to what was being discussed. And so this is the final question for Gary. ICE contends that the Escom program is not misused to target certain groups, but Escom inevitably operates in jurisdictions that practice racial profiling in their policing activities. What steps, if any, is ICE taking to ensure that it is not complicit in these types of negative activities?
Well, as I said just a little while ago, we have recently initiated a number of things. The statistical model that will allow us to see anomalies in terms of the cases coming out of a jurisdiction, the new complaint process that CRCL is involved in, and just the informational and training videos that we're distributing to state and locals. I think we're doing all those things, and a relatively minor, not minor thing, but a thing that cuts across all of our programs. We have a new detainer form coming out, which makes very clear that people are only to be held for up to 42 hours. It provides.
Gary, I think the question is, when you're in a jurisdiction that you know you suspect could be engaging in racial profiling, and there's an open Department of Justice investigation or a federal lawsuit, what are you doing to prevent secure communities from becoming an agent of racial profiling by the law enforcement agency?
Well, again, I don't think it's a question of secure communities. We have many programs, that do essentially the same thing. This is just a source of leads. And, if we are given evidence that there is racial profiling, we will do what we can to mitigate our involvement in that. And we've not been given that yet. So,
well, that's not true. I know that there are advocates who've provided memos and information to the Immigration Customs Enforcement Agency.
As you said,
and so maybe you're taking it under advisement.
As you said, their investigations are ongoing, and when the investigations are complete, if they show something conclusive, we will act on it.
I see.
Okay, well, going out with a bang. No. Well, I'd like to thank all of the panelists for all of your time and we hope this will, continue conversations about this topic and other immigration topics dealing with the justice system. So thank you very much.